with the 2024 election well underway, uh, we're here today to discuss the executive appointment process. My name is Patrick Duffey. I'm a partner in the firm's Private Wealth Services Group out of the Tampa office. I'm joined today by Bob Rizzi and by Charles Borden. Bob is a partner in the firm's tax group and co-teaches a class at Harvard Law on the subject, as does Charles Borden, who is the co-lead of the firm's political practice. Now, we ought to begin at the beginning. What precisely do we mean when we talk about the executive appointment process?
Well, I think what we're talking about is the process of people seeking appointment in senior executive branch positions of all sorts. So what Bob and I have found over the years that we've been doing this is that regardless of the administration, there are always people who are interested in serving their country and joining an administration as you get into a presidential election. And what they find is that the process of actually going into government is much, much more complicated than they ever imagined. I think all of them sort of get through the process and then try to just forget that they've had what it was like, because it can be quite burdensome. And what we have helped clients do of both parties for several decades now is navigate those issues and help them find ways so that they can think in advance about what are potential issues from a financial disclosure perspective, from a asset planning perspective, from a divestiture perspective, so that they can get through the process as smoothly as possible.
And Bob, what kind of positions do you see most commonly in this practice?
Well, it varies depending on the administration. One of the constants is that our clients are often considered for ambassadorial positions. But every time there's a new administration, there are 4,000 new political appointees. So 1,200 of those are Senate confirmed, and all of them have to go through the process that Charles described. So these positions can vary from cabinet positions to assistant secretaries to senior staff in the White House. And each one of those has its own complications and its own challenges, but all of them are filled by political appointees.
Well, I guess the wrinkle for 2024 is that now, either way, we're guaranteed to get a brand new administration.
That's right. I think certainly there'll be a considerable amount of turnover, even if there's a continuing Democratic administration. If there's a Republican administration, obviously there'll be a very, very significant amount of turnover. And as I say, there'll be thousands of positions available for political appointees.
I mean, even you've only had one, what we would call a friendly transition in recent memory, which was from Ronald Reagan to George H.W. Bush. And, sort of give you, I think, a bit of a benchmark. In that case, 3 of the cabinet secretaries from the last Reagan cabinet stayed on and served in the George H.W. Bush administration. So it's pretty significant turnover.
So anyone who's interested should be thinking about this process now.
Absolutely. I think the issue is that the process, as I said, if you're dealing with high net worth individuals, is really complicated. It's definitely manageable, but the concern is if you start down the path and you haven't thought through these issues, you can find a situation where you've essentially started a conversation with people who are the betters and surfaced issues or made commitments that actually would be very problematic. Either problematic in the sense that it'll actually cause you not to get the position in the end, which can be obviously disappointing personally and also professionally, can have some reputational impact. But also just commitments in the sense of financial ones that can be really damaging both in the short term and the long term, where you've agreed to you'll get the job, but you'll get it on condition of divesting assets for pennies on the dollar or things like that, which people don't want to do, or you'll be upsetting plans you've made regarding your estate and your long term sort of holdings that will now be torn up in a way that's not really thoughtful and only is designed really to deal with some of these short-term issues.
And this is why we're talking about this now, because we're already being contacted by individuals of both political parties who are interested in finding out more about the process. But once the election is over, there's a very short period of time between the election and inauguration day for people who are serious about these positions to get ready. And so the more preparation they do now, the easier it's going to be later. And so it's one of the reasons we're trying to alert people to these opportunities at this point.
And just to,
Please.
sorry, yeah, just to sort of, I think expand a bit on that. I mean, the thing I was sort of, mentioning a moment ago, Bob and I have been doing this for a couple of decades now, and we've worked, with nominees across administrations, Republicans and Democrats. And that means, we're repeat players. So we've really, been through this process with all kinds of different nominees for all kinds of different positions. And the institutional players in the process, like the Office of Government Ethics, the ethics officials in the various agencies, we've dealt with them for years. And so I think in terms of spotting issues for potential nominees, telling them these are the things that could be potential problems for their nomination, or these are the things you're probably going to have to divest, and you should think about how you can do that in the most efficient and the least costly way possible. We have a very good sense of what those issues are going to be for people.
So I think that both points are a good transition to talk through for a prospective nominee from a high level what we're talking about. What is the process? What are the the high points? To me, what I've heard so far is it appears that it begins in some version of the vetting process. Then there's a significant amount of financial disclosures involved, and maybe even some agreements to resolve those. And then finally, you're probably going to get hit with some version of needing to get a security clearance.
Mm-hmm. Go ahead, Bob.
Yeah, I mean the first step in this process is what we've called the political vet, which is individuals step forward. They want to do government service. They're identified by the new administration as being a good fit, and they go through some kind of a screening by the political side of the new administration. At that point, if there's an indication of interest, then there's a very significant amount of paperwork that needs to be completed. Generally, we ask our clients to start taking a look at those forms at this point, or at least early in the process, so they get comfortable that they are able to complete the paperwork. We usually start with the security clearance document, and that is a very detailed background investigation, generally going back at least 7 years, and in some cases 15 years, and trying to identify whether somebody is eligible for getting a security clearance. Most of the positions we're talking about require a top secret clearance. And so that's the initial form that we focus on.
Now, I understand that you yourself have gone through that process personally.
Yes, I worked at the Central Intelligence Agency, and I've represented people who have had security clearances denied. I've obviously represented many individuals through the security clearance process. We have some experience in identifying issues, and certainly that's a point where we can give a lot of background on what we've seen and what are sensitive issues, what are issues that could be managed, what are issues that may potentially be disqualifying. And so it's helpful to have that background.
I think it's important just to maybe expand a little bit on that in terms of the kinds of issues that we've seen clients run into problems with when it comes to security clearances. I mean, the security clearance form, as Bob said, it's really about trying to figure out whether or not you should be trusted with extremely sensitive information. And so, the issues that they ask about are things like connections to foreign countries, foreign interests. So, one of the things we've run into with a number of clients is having them map their foreign connections of all sort. And in this day and age, that can be pretty extensive. Particularly, one of the things you have to provide information on is foreign travel, and people can be traveling out of the country every week these days. Dual citizenship, family members in other countries, those kinds of foreign connections, those can be very significant and the kinds of things that people will ask about. I'd say another issue we see that comes up is legal proceedings, litigation. If you've had litigation, particularly litigation that goes to character, I would say, things like being accused of some form of fraud. Those are the kinds of things that can come up in a process. Obviously, family related litigation, marital divorce proceedings, allegations regarding abuse of that. All of that's the kind of stuff that gets questioned in the process. And then I think, you know, for it can we've seen it for as an issue for some of our younger clients, drug use, particularly this day and age where you have marijuana, being legalized at the state level, but still being a controlled substance at the federal level.
Now, the younger clients, that's a function of how far back the review is going.
Yeah. So as Bob said, the standard, uh, background check will go back 7 years, but oftentimes they go back 15. And so, if you were someone who is, late 30s, early 40s, 15 years takes you into your mid 20s. And we've definitely had clients where if you go back that far, they may have had some, as some I've called the youthful indiscretions, that get captured in this process. And it's not necessarily a disqualifier. It doesn't mean that they can't get a clearance. And Bob and I have plenty of experience with helping people get clearances under those circumstances. But it's something that needs to be explained. And one of the most important things that we tell clients when they're going through this process, which feels very invasive, is they can't lie. The single biggest reason people don't get security clearances is economic insecurity. They are capable of being bribed. They're in financial distress. The second most common reason they don't get a clearance is they lied during the security clearance process. We've had lots of people over the years who they just don't want to admit that they've done something wrong, or something arguably wrong, and they lie about it, and that's fatal.
So, Charles, I want to touch or move on here to the disclosure process, which we mentioned earlier. Now, in our practice, a version of disclosure, financial disclosures, comes up all the time. Nuptial agreements, post-nuptial agreements. I'm assuming this is a little bit more organized than that.
I think your assumption is probably right in part, and not in others. Basically, this is a process. We always call it. It's basically a snapshot process. It's designed to take a snapshot of someone's finances, essentially at the time that they're being nominated, and it is a process that dates back to the Ethics in Government Act of 1978, and that's important because when when Congress was drafting this legislation and enacting it, they were thinking about a person's financial holdings in through the 1970s lens. In other words, they were assuming that people held stocks, bonds, mutual funds. Maybe they had some like private real estate holdings, but they weren't thinking about the wide variety of financial instruments we see today. And so one of the things you often run into when you're trying to do this snapshot is dealing with a disclosure, set of disclosure requirements in a form that was not meant for sort of the modern portfolio. And so a lot of what Bob and I have to do with clients is help them work through how do they disclose some very, very complicated financial arrangements, using a rubric that was basically not meant for private equity holdings or with JVs with various institutional investors and things of that sort. Carried interest, for example, has been a huge issue over the years, but how do you disclose that appropriately? And so I think that's been a big part of the disclosure process. You're taking a snapshot, you're trying to disclose your assets, but you're doing so in a form which sort of assumes all you hold is publicly traded securities.
And now the framework to those assets matters too, right? So if there's a family office involved, trust or a series of trusts.
Yeah, financial disclosure, and it's very good to focus on that because that's one of the parts of this process that's pretty different from anything anybody has gone through in the rest of their careers if they're coming from the private sector. Trusts are a key part of the financial disclosure exercise. Private equity funds are part of it. Every part of somebody's financial situation is subject to disclosure one way or another. And formatting that, presenting it in a way that's understandable to government officials who may not be familiar with some of the subtleties of trust and estates planning, for example, is part of what we do. We act as intermediaries. We certainly uh, get a lot of assistance from the accountants for the clients, their financial planners, their other advisors, and work closely with them to try to make sure that we navigate through this process. The arbiter of all of this is the Office of Government Ethics, which is a unique organization in the government ethics area. And we've worked closely with OGE for many years. We've actually helped them develop some of these formats for disclosure and walk them through how these things should be presented. So it's an area where we can help clients a lot and ease the burden of what is a fairly onerous process, or can be a fairly onerous
So
process.
when our clients are coming in with a complicated application, they know, the OG knows who they're talking to, and you know who you're talking to at OG.
Yes,
Absolutely.
yes. Actually, OGE in the past has been willing to talk to us on a no-name basis, which has been very helpful. So, for example, if we have a client who has a particular issue, we're able to go to OGE and say, you know, what would your position be on this if our client had the following uh, potential problems? And that helps to ease this process as well. So
Yeah.
it's been a very cooperative process. And as Charles said, we're repeat players. So we have developed these kinds of contacts, and I think it helps everybody, including the government ethics process generally.
Yeah, and I mean, another piece of that is that, the White House, Office of Presidential Personnel, or the White House Counsel's Office, there will be times where nominations will get stuck. And we've definitely had situations where, the White Houses can recommend someone specifically, but they'll provide a list to nominees of lawyers they might want to consult. And both of us are on that list of lawyers who, the White House, and again, across administrations, has said, if your process is stuck, you might want to think about talking to these people and getting their help. I did want to just pick up, I think, one other thing on the financial disclosure piece, because I do think if people are thinking about it from the standpoint of net worth statements or things like that, there is some real differences in terms of what you're disclosing here. One thing that you do need to disclose, depending on the business you're in, is clients. So there's a part of the form which basically requires you. So the form writ large requires you to disclose your assets, your sources of income, and essentially your professional relationships. So, you need to disclose boards that you sit on, charities you might be associated with in a senior capacity, things like that. But one of the things that does require you to disclose is sources of compensation above $5,000. And to the extent that those sources of compensation are being paid to you through another vehicle, like a law firm in our case, but this is true for accountants, it's true for certain types of financial services advisors, where you have a client who is paying you, who's paying for your professional services. You need to disclose that specific client. So you'll get a situation for, if you look at like a lawyer who goes into the government, they'll list there's a source of compensation, the law firm they work for, and then they'll list every single client who paid at least $5,000 for their legal services. And you can think about some industries where, including law, where that kind of disclosure can be very problematic because you have confidentiality agreements and things like that with clients.
So on the asset side,
Mm-hmm.
supposing we have a client who's got a very complex set of holdings, maybe a closely held company. Why can't we fix this with a blind trust?
It's one of the most common questions we get is, why can't we use a blind trust? And the answer is that blind trusts generally don't work to avoid conflicts or disclosure issues, for that matter, because you know what's in the trust. If you contribute an asset to a trust, you know it's there. Blind trusts have very limited utility in this area, unfortunately. The only time where a blind trust makes any sense is if you put cash into the blind trust and then the trustee can invest that cash and not tell you what that cash is being invested in. The other problem with blind trusts under the OGE interpretation of blind trust, which is really all that counts here, is that you have to have a quote independent trustee, and that means a trustee that has really no prior relationship to the nominee, and there are really a very limited number of trust companies that are even willing to do this. So there are a handful of blind trusts that are in existence. We've worked with a couple of those, and they're very cumbersome. They're very unappealing for most nominees, and they really are not a factor in most of our planning for nominations.
Yeah, I mean, I think just to echo that, people think blind trusts are a way to hold things that are a conflict, and they're not. That you're blind to what to essentially what is done with the proceeds after you've sold the conflicted assets. You're not blind to anything else. So it's basically a structure, as Bob set up, where it's a great way for you to have your money invested after you've sold everything that you were trying to hold on to, but you're going to have your money managed by somebody who neither you nor your family has any prior relationship with, and there are actually very strict rules on how much you can communicate with them, so you can get almost no information about what they're doing. And once you sort of walk a client through those issues, they usually aren't all that keen to do a blind trust.
Makes sense. Our clients build the company, they want to keep the company, and then they also want to know how the company's doing. Blind trust fails on
Right.
all
On
those.
all those,
It's incompatible with the blind trust. Yeah.
So with disclosures, I'd imagine that you probably can run into issues both ways, meaning the regulations involved, are they written anywhere? Do we know exactly what to disclose and what not disclose?
There are regulations in the area. There are guidelines from OGE, but there is also a sort of unwritten set of guidance that you can only really get a handle on by practicing in this area, because there's just an enormous amount of custom and practice. It's unsatisfying in a lot of ways, but that's the reality. The interpretation of the rules by OGE is something that you can only really understand if you've been working with them. And as I say, we've helped develop some of that custom and practice over the years, as we've worked with OGE. So it's the short answer is there's some written guidance, but that's really not sufficient in the most difficult cases. So if somebody comes in, as Charles says, with a complicated carried interest arrangement with their funds, we know how that is supposed to be described in the disclosure form, but that's only because we've done it a million times. So it's really it's a matter of practicing in this area and providing that guidance that people need to be able to go forward with their nominations.
So it strikes me, Charles, you could probably go wrong either way.
Exactly.
Disclosing a little too much or a little too little.
And we've seen that, as we say, we oftentimes will find people who come to us midstream. They've already started the process. They've already had their accountant or some other lawyer fill out the disclosure, and it's become a mess. And it's become a mess for, both of those types of reasons. You've had some situations where they're clearly not disclosing enough. They're not providing the level of detail. The process has gotten bogged down. They keep getting questions from the ethics officials about, we need more information about this, and they're not providing the right information or sufficient amount of it. And then you get other situations where people have disclosed far too much information about their holdings. And the thing about it is that can lead to both, provide information about things people don't want to provide information about, but it also highlights for the ethics officials, things that they want to know more about. And you can find yourself running into problems with assets that would have otherwise not been a problem.
There's a downside to overshare.
There's definitely a downside to oversharing.
Okay.
Absolutely.
You mentioned something about working with other law firms. Now, that's in our own practice, something we find ourselves doing quite frequently. How often does it happen here?
I think it happens a decent amount. I mean, we have some very good, relationships with various, other firms who know that we do this, and then they don't. They recognize that their role with their client will potentially get problematic if they're the ones who have to come in and be sort of intermediating with the government, helping to understand, what these requests are, explaining what needs to be done. They lack both the experience and they also are differently situated with the client than we are. And so, a lot of times we will be working with, family offices who have longtime counsel, internal or external, where they're relying on us. And we've worked. I think if you think about major law firms who operate in this space, we've worked with all of them at one point or another.
Yeah, and I think, it should be clear now. I mean, this is a highly specialized practice. And so there are very few other firms that practice in this area, but most of our clients, I would say, have their own counsel or own advisors. And so our role is to help quarterback the process, but to use their advisors in the best possible way to get the information, to help interpret their holdings, to make sure that we've covered everything, to make sure that we have, accurate financial information. So all of those require a coordination with outside advisors, including outside counsel. We're very used to that.
So one thing I don't think we've talked about yet is how you get to a point where you've made your disclosures and maybe the OG has some issues with them, but we're ready to move forward to the next step. What's the way to get there?
So the financial disclosure is largely intended to help identify potential conflicts of interest, financial conflicts of interest. And the financial conflict of interest statute is a criminal code section. So it's a very serious requirement. And so once those financial conflicts have been identified through the disclosure, then the process of resolving those financial conflicts takes place. And so that can take a number of forms. You can provide for recusal, for example, that the nominee will recuse from decisions that could affect their holdings, or you can, in theory, get a waiver if the financial interest is small enough. But generally, the default is that the ethics officials will ask you to divest conflicted assets, and that's sometimes as simple if these are public securities, publicly traded securities. But if it's not publicly traded securities, if there are closely held assets or assets held in trust or other kinds of complicated holdings, structuring the divestiture itself is an area that needs help. And we are very experienced in helping figure out what those remedies look like and how they can be done and what's been acceptable in the past in terms of divestiture. And so can be a major part. If you're going into the cabinet, for example, the ethics officials will ask you to make major commitments to divestitures. And so that's something that people just have to take into account if they want to take one of those positions.
I mean, so what you have happened, if you're going to a Senate confirmed position, and you have this in a more informal way in non-Senate confirmed positions, you have essentially what's called an ethics agreement. Mm-hmm. It's an actual, it sounds like a contract. It's really more of a one-sided set of pledges. Mm-hmm. But you have a formal written document. You can find them if you online. You'll see what some of these ethics agreements look like. And again, as Bob said, for cabinet officials, these can go, be 10, 20 pages long. But they're basically a written, sort of set of commitments about how each of the conflicts that have been identified by the government, once they've looked through your financial disclosure, how you're going to resolve each of those commitments. And as Bob said, most cases it's going to be you're going to divest. You're going to divest within 90 days of being confirmed by the Senate, if it's a Senate confirmed position, or 90 days of taking office if it's not.
So I divest within 90 days. That feels like a big tax bill for a lot of these appointees.
Right. And this is where tax law becomes central. There are a lot of different tax issues related to the government ethics process, but one of the key provisions of the code is Section 1043 that allows you to defer the gain on required divestitures. And Section 1043 operates a little bit like a 1031 exchange. You have to have a replacement asset to track the basis of the asset that you sold, you're required to sell. And that replacement asset generally will be a diversified mutual fund, and that replacement property will preserve the gain, defer the gain until that replacement asset is sold. And Section 1043 planning is a major part of planning for some of these appointments, and it can be a very welcome opportunity for somebody who is committed to going into the government and divesting, and it mitigates some of the costs of doing that. And the deferral, we talk about deferral, but as you well know, if that diversified mutual fund is held into your estate, it gets a basis step up at death, and so the deferral is permanent.
And that could be for a pretty large portion of such a large portfolio.
Yes,
Absolutely.
So I wanted to touch on one more thing, which is the hearing process. That, to me, was what I thought we were going to talk about when I signed up for this. Turns out there's a little more you have to get through to get there. But why don't you talk about how that works and how we
well, again, there's a paperwork element to it. There's always paperwork in this process. It's a very form-driven process. Each committee of jurisdiction has a questionnaire, and the nominee will fill out that questionnaire, have it reviewed, have it edited, and then submit it to the committee. And then our clients will schedule a hearing, and some of our clients will actually ask us to help in preparation for the hearing through a murder board, which is the term that's used to describe the sort of the moot court equivalent for somebody who's going to be in front of a Senate committee to try to give them some help in preparing. But each one of those steps, we can help, we can provide guidance, we can give them some experience. Ultimately, that hearing will be a very important part of the process, and will determine, in some cases, whether they'll move forward.
Yeah, I mean, just a couple of additional points on that. One is, as Bob said, this is a form-driven process, and the Senate committee questionnaire is an important form, and oftentimes it's made public. So your responses there are going to be scrutinized. The other thing to keep in mind is, in a form-driven process, it's really important to make sure you have consistency across the forms, because the thing is, if you're going, to a Senate confirmation, the opposing party, whichever party that may be, is going to be looking at all of those forms, and they're going to be looking for inconsistencies. And you have forms that are asking about the same topics, but with slightly different, questions. And so having a good handle on how you're answering questions about your assets, about your conflicts, is critical, because if you do have an issue there, absolutely it's going to get caught by the congressional staff on the other side. And we have several colleagues who have been in that role, who previously served as Senate staff, whose job it was to fly spec these nominations, and they'll tell you that's exactly what they were looking for. I think the other thing to sort of keep in mind is that these hearings really can make or break a nomination. I mean, we were talking before about ambassadors, but there was a famous incident during the Obama administration where 3 ambassadors walked into a hearing and it turned into an absolute fiasco for them. They were asked a bunch of questions, they didn't have good answers, and several of those nominations never went forward because of that.
3 ambassadors walk into a hearing sounds like the beginning.
Yeah.
Yes. We mentioned earlier, both of you are adjunct professors at Harvard, teach a class on this subject. Why don't we finish up with a case study?
Sounds great.
I'm an ambassadorial candidate. I'm very serious. I picked out a residence, or maybe a top 5, and I'm ready to go. What do I need to start thinking about? What's my checklist?
And I should say, I've been to a couple of those residences, and it's worthwhile being an ambassador, I would say. It's a wonderful way to serve your country and to be in the middle of some just fantastic experiences. So as I said, the general way that this starts, and I'll just maybe talk about the first phase of this, is a potential ambassador is contacted somebody in the White House, a person in the White House says, congratulations, you're being considered by the president to be the ambassador to country X. That's the good news. The not so good news is here's a list of all of the forms you need to fill out. And so the individual at that point hopefully will contact us and say, never seen these forms before. How do I do it? And usually we say, please start with the security clearance form. Let us know as you go through it if you have any questions. And then we work with them to try to finalize that form and get that submitted, because the security clearance process takes a while. And so it can be kind of a gating issue for timing. And so that's really what we generally advise in terms of the process.
Right. No, absolutely. I think, to sort of recap some of the things we've been talking about. I think you want to think about, if you're someone who's interested in being an ambassador, they've come to us, we would say, let's figure out if for each step of the process, what are your potential issues? And so, for the political vet that we were talking about, what are some things that when the White House or a transition team is interviewing you, what are the kinds of things that they might say are politically problematic? Do you have any, high profile litigation? Do you have any criminal issues? Do you have any tax issues generally? Have you ever been accused of not paying your taxes?
Review the Twitter account.
Yeah, review social media posts
these days for sure.
Any sort of public speaking, any books you've done, any video presentations you've made. Have you done anything that would be politically problematic? And they're going to ask you for all of that. They're going to ask you for all your social media passwords. So review it now and let's see if you've got an issue that's going to potentially be a showstopper. Then, to Bob's point, let's think about the security clearance process. You're going to fill out this form. We talked a little bit about the kinds of issues that get people into trouble. What are your foreign connections? What are your foreign business holdings? Do you have any drug use issues we should be talking about? Have you had any legal proceedings that were contentious or that involved allegations of misconduct or things that go to your character? The kinds of things that we know people doing a background check are going to ask about. Then with financial disclosure, we've been talking about it, but when you're filling out this form, do you have the kinds of assets that this form wasn't meant for? Do you have a lot of private equity holdings? Do you have a lot of holdings that are held in family trusts, maybe multi-generational trusts that are going to be hard to fully explain on this form? Are you in a client service business where you're going to have a client list that might need to be disclosed? Do you have executive compensation arrangements? We didn't really talk about that might be complicated to explain on this form. But what do you have any of the kinds of sources of income, relationships, or assets that are going to be difficult? So we can talk about how best to deal with those. And then this issue with remedies, which is if once you identify these assets, what are the kinds of assets that will be hard to get out of? What are the situations where assets are held in trust, whether they're held again, the private equity investments or other types of investments where there's a long lockup of some sort, all of those sorts of issues. Let's identify them now and think about, are there some planning opportunities like, where, as we were talking about, 1043 rollover opportunities. But I think the idea would be to go through and do that kind of comprehensive upfront analysis so you can make a realistic assessment of, what are you getting yourself into if you want to go forward with this? Or are you going to make it through? Based on our experience, do we think you're going to be able to make it through? And if you do make it through, what are you looking at in terms of potential costs, both, reputationally and also financially?
On this hypo, I've already hired the two of you, so I feel pretty good about it.
So the conflicts that Charles is talking about, that analysis is somewhat complicated because ultimately the conflicts are going to be determined, potential conflicts are going to be determined by the State Department. But we can give some advice as to what we think some of those conflicts might be. We had one client who is going to be an ambassador to Italy, and he owned a winery in California, and we were very concerned about that because we thought, oh, that would be a potential conflict. The State Department thought that was quite amusing because the idea that Italy would worry about California wines was a stretch, and it turned out not to be a problem at all. But we can give some advice about those potential issues to help them think about what might be involved in serving. And then, as we just talked about, I mean, getting prepared for the Senate hearing is something that we can provide a lot of help on. And the legislative branch of the State Department provides some background for nominees, but we find that our staff can provide even better background on some issues and can prepare nominees as well or better than some of the officials. And clients will come to us for that kind of help as well.
Well, great. I appreciate you both taking the time to join us here today. We look forward to an interesting 2024 election season, and I'm sure that we'll be talking about many of the political appointments that happen either way.
Well, thank you, Patrick. This has been great.
Thank you very much. Yeah, appreciate it.